my lords and my lady, good afternoon. I was going to go to legislative purpose,
Yes.
which I hope will bring out some of the points I was making this morning. Now, legislative purpose in this context, in this relation to this provision, has two aspects to it. One is to use a shorthand, the anti-fraud purpose. And the other is the importance of formal requirements when it comes to land. And it's widely known, of course, that there are formal requirements when it comes to dealings in land. Now, on purpose, there seems to be some common ground about the purpose of this provision. The retirement fund's main skeleton, paragraph 28, which is CB tab 7, page 76, says that the purpose of section 53(1)(b) is to prevent fraud. It protects against fraud on the owner of property in question by persons claiming to be beneficially entitled. And similarly, in NIOC's supplementary skeleton CB 25, page 342, at paragraph 29, they say that subsection B and predecessors were enacted to protect landowners from perjured witnesses falsely claiming the landowner had declared a trust in favour of the third party or a third party. And if one goes to the preamble to the statute of frauds, which preceded these provisions, at Authorities Manual 1, tab 1, page 11, one sees at the foot of the page in chapter 3, just under the chapter 3 heading, an act for prevention of frauds and perjuries, and the right-hand margin has reasons for passing this act. And the first sentence, for prevention of many fraudulent practices which are commonly endeavoured to be upheld by perjury and subordination of perjury. Now, the legal texts are to similar effect. I won't go to all of them. The Hayton's Law of Trust is clear on this, but it's quoted in Haley and McMurtry. If we could perhaps look at that, which is Authorities Bundle 5, at tab 162, and in this respect, page sorry, 160, page 4.
Page 4.
I beg your pardon, wrong reference, page 3, I do beg your pardon.
Page 3.
My apologies to the court, I pulled up the wrong document for myself.
It's the one you want.
It is Authorities Bundle 162, and it's page 4. Excuse me one moment.
Yeah, it's exactly what you want, isn't it? It's paragraph 4.004.
There is I see where I've gone on my notes. There is reference to 404. It's the passage your lordship's rightly identified. Starting at the fourth line, these extra evidential requirements are imposed because both the value of land and the highly technical rules that attend its transfer, the settler is saved, as Hayton puts it, from the perils of oral evidence being misused to deprive him of his land. And I wanted also to show you passage in 4.006, which is on page 8 of the same extract. At the foot of the page, the signature envisaged will usually be that of the settlor. It has, however, been argued that if legal title to the property has already been transferred, it's the owner of the equitable interest who must sign and not the original settlor. If the trustee were given the mandate to declare a new trust in that scenario, it would appear the trustee's signature would be required. There's no express mention made in section 53(1)(b) of the ability of an agent to sign the document. This limitation exists presumably because the written evidence of a trust of land can emerge informally and unintentionally, and hence requires the declarants direct involvement. So the direct involvement of the settler is being referenced there in the question of fulfilling the legislative purpose. The Virgo's Principles of Equity and Trusts at Authorities Bundle 164, page 3, is, I'll just read the last few lines at the top of the page, the marked passage at the top of the page. Although the signature will normally be that of the settler, it can be that of the trustee. These formalities are required as a safeguard against fraud and abuse of trust to ensure that the settler is aware that they want a trust to be declared and as a means of standardizing transactions. And perhaps just finally, one more citation here at Authorities Bundle 139. This is Gray and Gray's Elements of Land Law, and in this respect at page 3 of the extract, we have a passage at foot of the page under purpose of the requirement of written evidence. And perhaps I could just invite the court just to read that paragraph, if I may.
Have you got a PDF number for that document?
Yes. 3 days. 1393.
Tab 139 page. It's 2880.
2880.
2880.
Thank you.
Now, it alludes to the two related functions, avoiding controversy arising from mistaken or fraudulent allegations of ownership, perhaps many years after the event, and the general disfavour shown by English law towards informal mechanisms for the creation of property rights in land. It also makes the point about intention on its own not being sufficient, which I'll to create create a beneficial interest, which is a point which I'll come back to in another context. But when one causes to consider with the legislative purpose in mind the appellant's construction and how that fits in with the legislative purpose, in our submission, both aspects of the legislative purpose are undermined. The appellant's interpretation would remove the need for settler involvement at any stage in the process before the trust can be enforced, and thereby exposes the landowner to a much enhanced risk of fraud by an agent or stranger purporting to evidence a trust over their land. All the more so, we suggest, because on the appellant's interpretation, the agent would not even have to be authorised in writing. That's the appellant's case. Orally appointed agents are within B. And it has to be the appellant's case because of the absence of reference in writing in B, bearing in mind that the thrust of their argument, that the reason why agents are mentioned in A and C and not in B, is to bring the requirement of writing into those subparagraphs and therefore not into B. If the appellants are correct and the settler can declare a trust of land through an agent, as to which I mentioned previously, there's no authority in point, but if that's right, then it removes the need for settler involvement at any stage. And that's the first aspect of legislative purpose, my lords and my lady. The second aspect, of course, and they're related, these aspects, they're not separate. The second aspect is the importance of formal requirements in relation to land. And they're related because, of course, if one brings in certainty and written evidence, you greatly enhance the function of the anti-fraud purpose. Again, in relation to this aspect, there doesn't seem to be much dispute about this aspect. The Retirement Fund Supplementary Skeleton at paragraph 42, which is CB tab 26, page 363, says that statutory formalities such as section 53(1)(b) serve a valuable cautionary and evidential function. Now, that's at paragraph 42. Now, the legal commentators go into this aspect in some depth in the articles, and they've been cited by the parties. They sometimes categorize the functions served by formal requirements here in slightly different ways, but the common themes are that they emphasize the cautionary and the evidential functions. And the cautionary function is, of course, that they encourage the maker of the document to consider its effect before signing, to pause, to appreciate they're doing something significant, and in our case, giving effect to a trust over land, which may be very valuable indeed. It encourages them to stop and think, what am I doing here? Have they given the transaction adequate forethought? And have they ensured that this is their final intention, which causes problems in the cases as well. Now, declaring a trust over land is a very significant thing to do. You can informally, orally in terms of the declaration, transfer the economic interest in an asset of huge value by a few significantly chosen words. And once evidenced in writing, it can't be revoked. It's a point made in Hackney's Understanding Equity and Trust. It's the Authorities Bundle 134, tab 2. Maybe worth having a quick look at
Page
that.
2.
It's page 2, yes. And it's the point made just below the middle of the page. This is a formidable weapon. You'll see those words in the middle. I can informally transfer to you my economic advantage in chattels of huge value by a few significantly chosen words, and once simply done, the act cannot be revoked. And in self-declaration cases, the settlor will also be taking on fiduciary duties, fiduciary obligations as trustee. Now, of course, personal assets can have huge value as well. But land has always had a special significance in the law, and rules relating to land have to be strictly enforced. As we have put in the pathway case into the bundles, which is in which my Lord Justice Zacaroli was the judge, where your Lordship applied and strictly applied Section 2 of the Law Reform Miscellaneous Provisions Act, contracts for sale on land. If your Lordship wishes to look at that, it's Authorities Bundle 93. At page 6 is the relevant passage. And
Before you go on, you said a minute or so ago that once evidenced in writing, a trust over land can't be revoked. But doesn't Ong and Ping demonstrate that you may not be able to revoke an oral declaration because the process of doing so provides necessary evidence?
there is potentially something of a conundrum there. Could I revert to your ladyship on that when I come to Ong and Ping, because I'm going to come to that case, and I take your ladyship's point that there may be something of a conundrum about revocation if the mere fact of attempting to revoke and referencing the trust might itself be evidence of a trust or a previous trust.
Okay.
On the question of pathway, my Lord, Lord Justice Zacaroli was dealing with a point. It's page 6, we have it on screen, and putting it simply, was pointing out and applying Section 2.1 of the Law of Property, as those Provisions Act, that the contract for sale had to not just be evident to be in writing and not just evidenced in writing, and indeed it had to contain all the relevant terms. And so it has been the policy of land law in this country to have formal requirements which are strictly enforced. Land is a limited resource. It still commands huge values and is frequently a person's most valuable asset if they're fortunate enough to own land. And if you remove the settlor from the entire process, by which a declaration of trust over land becomes enforced, then you undermine this aspect of legislative purpose in our submission. Whereas, just to quote you, Dan, usually the settlor's signature also tends to militate against the inference that the writing was merely a preliminary draft or a haphazard scribbling. Now, yes, Mr. Thankey yesterday suggested that the cautionary element would be lessened in one particular case, it was suggested, because you could make a declaration of trust without subjectively meaning to declare a trust. So there wouldn't be a particular cautionary aspect to that case. And that may indeed be right in a few cases, that trusts might be created without a subjective intention to create a trust, but only an objective one. But in the vast majority of cases, settlors are acting deliberately, as they should be, and there will be quite a significant cautionary function so far as this is concerned. Now, as to the evidential purpose, which is obviously in our submission fulfilled by Section 53(1)(b), it plainly promotes certainty. Writing and signature are a significant safeguard against the possibility that the alleged declarations of fabrication. It creates evidence in a reliable form, from which it can be determined whether the transaction was intended to be the creation of a trust. It provides permanent evidence for the future, and often, as we know, land can be held for long periods, or evidence of what the terms of the transaction were. Now, in our submission, that function is significantly eroded by the appellant's construction, because it opens up a package of disputes and potential disputes as to the validity and scope of the agent's appointment, the reliability of the agent's evidence in circumstances where the agent can be appointed orally, and where the agent may be creating or providing evidence of the trust many years after the event, or many years after the declaration of the trust. It would also, in our submission, leave open arguments as to whether the ostensible or apparent authority of an agent sufficed for the purposes of Section 53(1)(b). That also being part of the general law of agency. And indeed, if so, whether ostensible authority were made out on the facts. There are potential disputes about whether the agent's authority remained current and the settler hadn't changed their minds. which causes issues in the cases. You'd have potential issues about whether common law principles of ratification were imported as well into 53(1)(b). And that does seem unlikely, the idea that an agent with no authority, an unauthorized person, can be some person able to declare a trust. But there would be questions to be addressed as to whether they became some person if their actions were later ratified. And that, again, could be done orally. So you're inviting that type of dispute as well.
It may be the appellants, as I understand it, they are relying on the is able to
Yes.
wording, which maybe they would say is therefore confined to existing actual authority.
Well, then you have the difficulties of which parts of the common law are included and which aren't. And how do you explain what the statutory purpose of that was? Because these are questions that would have to be resolved if agents come into being. Sensible authority, the ratification. I mean, we say it seems it is an available reading of those words to say you have to be authorized at the time. It is of making a declaration. It is an available reading, but equally, as there have been in other parts of the LPA, there have been debates and cases on whether ratification is included. And you'd have to have that debate in relation to B, because there's another point about B which I'm going to come to, which is that on the appellant's construction, you're dipping in and out of different bits of the common law of agency. It's a sort of select the bits you like type attitude. But on the current point I'm addressing, I mean, these are just further invitations for disputes and uncertainty. Because, you know, your next case would be, does ratification apply? Now, and then if the settler's agent...
See what the justification is for restricting it to agents with actual authority. If an agent with ostensible authority has authority as a consequence, as a matter of law, then why isn't that agent equally someone who can sign?
Well, I think there would be...
I'm just making the principal point in your favour.
Yeah, understood. Understood. There'd have to...
I mean, maybe your point about dipping in and out, if it limits it to actual authority, agents with actual authority, it's difficult to see what the logic for that is.
Yes.
You either include somebody's agent or you don't.
You're either in or you're...
And only an authorised agent would be covered, but there are many ways in which agents can be authorised.
Yes. And no doubt each one would give rise to disputes uncertainty directly contrary to the legislative purpose, which was to have this evidential purpose, to actually create reliable evidence from which these things could be determined as to whether there was an intention to create a trust and to provide permanent evidence of that. I mean, then another point which arises is if the settlor's agent can provide the evidence, what about the trustee's agent? In a transfer on trust case? And then you get the same issues again arising to that. But of course you get to once you've got to the point of a trustee's agent, you're really getting further and further away from the certainty of the settlor's intention. I mean, you're several steps removed from that. And you stand back and you think, well, was that really intended by this legislation? The legal commentators address, a number of them address this at some length, the legislative purpose of the section and the formal requirements in relation to land generally, and what a good thing they are and what good reasons there are for them. And I'm not going to take you through all of them. I might just show you a couple. Gardiner's Law of Trusts at Authorities Bundle 5 Authorities Bundle 5 at 144. top of the page, sorry, page 3, top of the page. Trusts of land are particularly likely to be made formally in practice. People making dispositions of land are especially likely to perceive that they're doing something significant, will almost certainly use professional advisors, who will always want to put important matters down on paper. So as with wills, the danger of a requirement of formality frustrating the settler's intention is slight, allowing the balance of advantage to come down in favour of its imposition. Professor Charles Harpham's article, which is much relied on by the appellants for his opinion about agents, in fact, very properly identifies the most important aspects of and functions of formality in land law. That's at Authorities Bundle 5, 136. In this respect, page 7, where you will see in the bottom part of the text, he identifies the most important functions of the cautionary function, the evidential function, and the channeling function, which is really about standardizing transactions, particular types of transactions. These classifications, by the way, they come from originally from an older article by Fuller, which I don't think it's necessary to take you to, but just for one more citation on this, in Authorities Bundle 5 at 135, Critchley's article, here, page 9, has quite a, for those who are interested, there's quite a lengthy discussion about the pros and cons of formalities in relating to land. And I'm obviously not going to go through the whole thing, but you'll see in the middle of this page, page 9, that she refers to land law being hedged about at almost every turn by formal requirements, and then goes on to consider the benefits and detriments of formalities over the next pages in that context. And we see, for example, at page, bundle page 13, the benefits of formality. You see the cautionary function at the foot of the page in warning parties from the viewpoint of the parties to the transaction. It warns them. There's a discussion of that, and that, of course, a point made over the page, at page 40, in the bottom of the page, in the last paragraph on the page, makes the point in the first sentence that these formalities may also produce the effect that they lead to the involvement of legal professionals. Quite right too, and then over the page at page 50, bundle page 15, we see at the top of the page a third benefit of formality is that it helps to clarify the terms of the transaction. And then foot of that same page in the last paragraph of text, the next and perhaps most obvious advantage is the evidence which it secures.
What's being talked about here in terms of formalities? Because there is a difference between A and C, which are actual formalities for the creation of interests, and B, which is purely evidential. What's she talking about here?
Oh, I think she's talking about land, formal requirements in general relating to land transactions. She's not specifically addressing this to section 53. But I would suggest that section 53 is exactly the sort of provision that the author has in mind here. And you can see, well, I mean, you can see how these apply directly to the section we've got under consideration. And indeed, it isn't just for the benefit of the parties. One sees from page 17, the author on page 17, AB 135, page 17. The author towards the foot of the page in the middle of the last paragraph, indeed in the last paragraph, looks at the benefits of formality to the courts in producing evidence for the purposes of disputes before the courts. Now, the retirement fund has raised in their skeleton the issue that strict compliance with formal requirements can frustrate settler intentions, that's also discussed in some length in some of the legal text. I mean, they say there can be a tension there, and that's true to some extent. And it's also true that the tension can sometimes produce hard cases. But all the writers recognise that there are good reasons for these formal rules being in place, and hitherto that has been the policy of land law in England and Wales, and there's no sign that that is changing. And just to give a couple of further references, I won't go through them, on the good reasons for the rules and the potential for tensions. They're discussed, Davies and Virgo discussed them at Authorities Bundle 5, tab 151, page 14 of the bundle, and Critchley discusses them at Authorities Bundle 5, tab 135, bundle page 19, and going forward. And the fund, the retirement fund, also in their skeleton take the point, and I think some degree orally, that if the consequences of a particular construction are more likely to be adverse than beneficial, then that tells against the construction. But one obviously has to look at adversity and beneficence according to the parliamentary intention, not the subjective wishes of one party to litigation. Opposing constructions frequently have consequences which go in opposite directions. And if it's useful to weigh them, they ought to be weighed from the viewpoint of the community at large and not from the particular litigant that wants a particular result. I mean, our constructions have many, many positive benefits that I have outlined, which significantly outweigh any potential detrimental effects. There may be cases where a settler's intention will fail because of a failure to comply with section 53(1)(b). That is in the very nature of this kind of provision. How many of those cases are viewed as genuinely unfair results is of course a matter of debate. It may depend on the reason for the failure. It's open to debate. It's always open to debates whether ignorance of the law could make something unfair, but it isn't usually a good excuse in other areas of the law. And as the texts make clear, when you're dealing with something important like land, you should, frequently the case, you should get legal advice when you're doing that. And I also point out that the law does provide other remedies for potential unfairness, like proprietary estoppel, which may apply if the person who thinks that there's been some trust arrangement made in their favour has in fact invested in the property to their detriment, for example. Constructive trust remedy might be available, as was discussed yesterday. But what you can say with some confidence is that if you construe this subsection to permit agents, and indeed orally appointed agents, then you significantly undermine the positive benefits of the section and the protection that it gives to settlers and the certainty of transactions that it provides. There was I think a suggestion by Mr. Grant yesterday that there might be transactions out there which will fail because if you construe B to exclude agents. And he took you to the TR1 form at SB 2 tab 47, page 387. TR1 form in this case. Now, I think he showed you this page, and there was also discussion of the Declaration of Trust, box 10, which is on page 386 of the same document, you were shown what 10 provides, where the transferee is more than one person, place X in the appropriate box, declaration of trust, etc. And then the signature page is back on 3H7. And interestingly, well, one should look at the notes opposite the signature in the second box of notes on this form. It says if there's more than one transferee and panel 10 has been completed, each transferee must also execute this transfer to comply with the requirements in section 53(1)(b) of the Law of Property Act relating to the declaration of a trust of land. And that's emphasised, and I hope we had a look at that guidance as well. It says the same thing. The transferee, each transferee must also execute this transfer. If you are a box 10 case, you are told in terms, each transferee, doesn't say agent, says each transferee has to execute the transfer to comply with section 53(1)(b), which is correct, because that's the law. And Mr. Grant was saying, well, what if they've been wrongly filled out and people have signed by their solicitors? Well, the solicitor ought to get the client to sign. It has been known for 100 years that section 53(1)(b) makes no reference to agents, unlike subsections A and C. And that, to put it at its very lowest, there was a real doubt or an open question as to whether an agent's signature would suffice. And that hasn't proved to be such an issue as to compel amendment of the subsection in 100 years of its life. My Lord Justice Zacaroli asked earlier in this hearing why there were not multiple cases that might have been thrown up to test the section. And I would suggest that the inference is that it's because solicitors get their clients to sign once involved. You remember the passage from Gardner that the Gardner text that I showed you about people making dispositions of land are likely to perceive they're doing something significant, they're likely to get legal advice, and so forth. And if you haven't got the appropriate signature in these circumstances, then there's not a huge scope for unfairness. These are not onerous requirements under B. Some writing signed by the settlor or a trustee is not an onerous requirement. And as I've mentioned, there are other potential remedies that on the facts might be available. And just finally on legislative purpose, before I move to the appellant's rationale for saying why the subsections are different. Property fraud remains a real and rising concern in England. I mean, you only need to look at any newspaper. There are many different forms of property fraud. Some of them are very sophisticated. And they can involve property being, or an interest in property being sold without the owner's knowledge. The IDs are stolen and so on. It tends to be rental properties or empty properties and so on. But are we really saying, rhetorically, are we really saying that in these, that we're going to relax the requirements around 53(1)(b) so the owner doesn't have to be involved in a declaration of trust at any stage of the declaration of trust in these circumstances? In my submission, it would be a very detrimental step to do that. Turning to the appellant's suggested rationale for why there are agent references in A and C and not in B, that, I'm afraid, is entirely unconvincing as a justification. It said, you'll recall, by the appellants that the reason why agents are specifically referenced in A and C and not B is to provide for the authorization of the agent in writing. It said that if express provision was not made for the mode by which agents could be authorized, it would be possible for agents who were orally authorized to execute such conveyances or disposals, and that would undermine the policy of the section, which are derived from the statute of frauds. That's NIOC's main skeleton, paragraph 26, CB, tab 6, page 51. Now, that's entirely unconvincing, and a number of points are relevant here to explain why. It's entirely understandable that the legislature should stipulate for an agent executing a written conveyance or disposition in A or C to be authorized in writing to protect landowners from fraud, or the fraud of those purporting to be their agents. It also serves the function of certainty. But the legislative purpose of preventing fraud applies in our submission with equal force to subsection B. Indeed, since declarations of land can be made orally, in our submission it's even more important that formal requirements to protect against fraud are applied to the evidence required of that trust under B. In our submission, it makes no sense to tighten the rules on A and C, but leave B such that orally appointed agents could provide the required evidence and the much enhanced risk of fraud and uncertainty that entails. The answer, of course, is that the legislature intended no such thing because it didn't intend agents to be in B at all. And just to develop that point, the dividing line between 53(1)A and 53(1)B is not always clear. If I could just quickly on this cite at the authorities, bundle 5, tab 151, Davis and Virgo, just to explain that point. At page 5 of this extract,
Front of page.
it's
3040.
3040. And we have it on screen. It's not actually the marked passage. It's the passage. It's the paragraph above the marked passage, where they say, within section 53(1), there is potentially some overlap between paragraphs A and B. Paragraph A concerns the creation of an interest in the land, whereas paragraph B concerns the declaration of a trust respecting land. Two are not mutually exclusive. The absolute legal owner of land might declare himself to be holding the property in trust for his children. In such an event, should paragraph A or B apply? The answer is not obvious. But it's suggested that if paragraph B is to have any scope of its own, then it should apply to such situations. And we would respectfully, well, inevitably we would say that was right. But the point really is this, that given the close relationship between A and B and the somewhat ill-defined boundary between them, it is with respect untenable to suggest that the anti-fraud legal policy behind the subsection should be different or somehow less for 53(1)B. And the answer, of course, because as the NIOC's main skeleton says in terms, allowing orally appointed agents fatally undermines the policy of A and C. And obviously it does so for B. If it would undermine it for A and C, orally appointed agents would undermine it for B. And the answer, again, of course, is the section did not intend to introduce agents into B at all, let alone orally appointed agents.
Does the congruence of A and B cut both ways though? So then the question arises, why, if they're doing similar things, is an agent allowed in A, but a written authorised agent is not allowed in B?
Well, I think the stronger inference must be, we would say in our direction, that if the policy, if you start from a similar anti-fraud policy, which does it dictate in respect of what you want to achieve with these sections? In A and C, it dictates written agents appointed in writing. In B, it dictates no agents, because as we've said, if agents have been tendered, it could have used the language it uses elsewhere. Some person lawfully authorised.
Is there a point as follows, that an actual transfer would tend to be, this is more important to A than C, I think, would tend to be a formal document these days, like a TR1.
Yes.
B doesn't need very much, and a written authorisation to an agent might well itself be enough to amount to a declaration of trust. In other words, it can be quite informal. So one approach might be to say that the legislature didn't think it was necessary to make
Yes.
any provision for agents in B because it's of its nature a potentially informal.
There is certainly something we've considered, that you could see A and C arising in a more formal contractual context. One can certainly see that, which may be an explanation as to why the legislature put in agents lawfully authorised in writing, because to do a disposition or within A, you were likely to have solicitors involved.
Well, and it could be, it would have been a transfer deed or nowadays a TR1.
Yes.
As I say, the point is less significant for paragraph C, I suspect.
Although one could well see it may be more likely you've got lawyers involved in a C situation. One can see that. But when you look at it all in the context, the solution of the legislator is not to suddenly widen B and say all agents, orally appointed agents. The solution has been, in B, we're not concerned with agents. And we're not concerned with that more contractual situation where you're sitting there with your lawyers having an authorised, who have been authorised by a written retainer. And I made the point a moment ago about the appellant's interpretation flipping in and out of the common law. I mean, what I meant by that was, and it's really unconvincing, is that their interpretation proposes a construction which flips in and out of the common law of agency as you go through the section. Because A, you depart from the default position that an agent can be orally appointed. And then B, according to them, you flip back into the common law position of oral agency. And then C, you flip back out again into written appointed agents only. So it's kind of, pick and mix as far as they're concerned. And it's also construction, as I think I mentioned a moment ago, results in the anomalous position that B, which doesn't mention agents at all, becomes more permissive than A and C, which do. And we submit there's zero justification for a legislative policy which says that we will introduce a writing requirement to minimize proof of oral testimony about the agent's authority in A and C, but when it comes to declaring trusts, we'll allow orally appointed agents. That's fine. And just to deal with Professor Charles Harpham's point in his article, which is relied on by it's at Authorities Bundle 5, tab 136, page 10. The argument there, he does acknowledge the controversy in this passage. He acknowledges there's a controversy, and he then says that the reason for the difference is that A and C require something to be done in writing, whereas B only requires it to be evidenced in writing. Now, whereas B does, on the authorities, serve an evidentiary function, it still requires something to be done by a person, just like A and C, it has to be some writing signed by some person. And that something is very significant in terms of land law formalities. Indeed, it's the only fraud protection conferred by the Act in relation to declarations of trust of land. And in fact, the fact that the protection has been reduced to an evidentiary provision is, in our submission, emphatically not a reason to reduce it further to allow agents to come into subsection B or allow orally appointed agents to provide the evidence. Now, I said I would make a point on the legislative history, and I'll try and do so quite briefly, but it is quite an important point because it's quite revealing. Broadly speaking, as Mr. Grant explained, the matters now addressed in section 53 were dealt with respectively in section 3 of the Statute of Frauds for 53(1)(a), section 7 of the Statute of Frauds for 53(1)(b), and section 9 of the Statute of Frauds for what is now 53(1)(c). And Wolstenholme's commentary deals with this, but Mr. Grant made the point yesterday, so I don't think it's an issue. Now, if we can look at the Statute of Frauds again, in Authorities Bundle 1, tab 1, page 11 is where the preamble was, where we were a moment ago. Then over the page to the actual provisions, what you'll see, so the three we're concerned with are 3, 7, and 9, which you find on this page. So it's 3, 7, and 9. 7 is the one that became 53(1)(b). And so looking at 3, which became 53(1)(a), you'll see the Statute of Frauds introduced agency and the requirement of writing to section 3. I won't read it all out, but it's in the last 2 lines of section 3. Their agents thereunto lawfully authorised by writing or by act and operation of law. So the statute introduces agency and the requirement of writing to section 3. The statute did not introduce that to section 7, which became our section. If we look down at section 7, there's no reference at all to agents, and nor did it introduce it to section 9, which further down, the one that became 53(1)(c, no reference at all to agents, just reference to the party. The party is the same expression, the party in 7. Now, when 250 years later, in the Law of Property Act, the legislators came to this, they maintain agency in writing in what became 53(1)(a). They maintain that, had been section 3. Then they introduce it expressly into what is now 53(1)(c), was section 9. They introduce it expressly, agent thereunto lawfully authorised in writing. But they still did not introduce that language to 53(1)(b), which had been section 7. And the legislator could easily have done so in 1925 when they did exactly that in section 53(1)(c), but they didn't. Now, what that tells you is that across 2 rounds of legislation, the agency language was left out of what is now 53(1)(b) and its predecessor section 7. And in our submission, the omission very much looks deliberate.
Is there any learning whatsoever on the interpretation of C and its relationship with agents section 9
9.
in the 200 and whatever years between 1677 and 1925.
I am not aware of it, but I'm sure those behind me will be seeking to answer that question, my lord. This statutory evolution suggests to us that there is a clear intentionality about the use of the word agent in these provisions. And it all looks intentional. And by the way, the statute of frauds was also perfectly, as we saw, it's able to distinguish when it wants agents, when it doesn't want agents. It was also perfectly able to distinguish when it was going to allow agents appointed orally or agents where agents had to be appointed in writing. Because you see that from, there are 2 occasions when they don't have to be appointed in writing. They just have to be lawfully authorised. That's section 4 of the statute of frauds. You'll see that in the last 3 lines of section 4. Some other person thereunto by him lawfully authorised. In section 4, that's the one about contracts and guarantees and so forth having to be evidenced. And the over the page, at page 13 of this of the statute, and down in paragraph, section 16 of the statute of frauds, you again get the use of agents thereunto lawfully authorised in section 16. So the statute said when it wanted agents and said when they had to be authorised in writing. Now, all of this is in the appellant's construction is putting huge pressure, which in my submission it will not bear, on the change of words from the party in the original section 7 to some person in 53(1)(b). The party who is by law enabled to declare that such trust was the original wording in section 7, and it becomes some person in 53(1)(b). Now, the party as it was.
Can we just go back to that page?
Sorry, it's
Page
Authorities
12.
Bundle 1, page 12.
Thank you.
Authorities Bundle 1, page 12. The party is in the penultimate line of 7. It's also used in 9, in the middle of 9. Now, the party was already in section 9, as we see the party granting or assigning the same, which is now 53(1)(b). And it plainly didn't cover agents because it had to be amended when it became 53(1)(c) to cover agents.
Well, that slightly begs the question I asked earlier, because it might have included agents appointed orally.
We'll see if we can to find anything on it. I'd be surprised if we can find anything in point, given the researches that have been made, but we will double check.
The signed by the party granting or assigning the same.
Yes.
Rather suggests a focus on the person who.
On the individual. On the individual, it does. And in parallel, the old section 7 of the statute of frauds, that already had the party in there, who is by law unable to declare such trust. And we would say that equally didn't cover agents, as the old 9 didn't cover agents. And it wasn't amended with the agency reference when it came to 1925. And all of that takes on a particular significance when you pull in the other sections I referred to before lunch. And you look at the pattern of how the Act says when agents are required and says when they're not.
It's not much.
Yes, we're just looking at the Maitland lectures on the statute of frauds, which points out that the sections 7 and 9 don't say anything about signatures by an agent in the statute of frauds. but they don't cite an authority which as to how the cases have interpreted that. Perhaps if there were one, we would have seen it in the Maitland lectures. But the other thing that's apparent in my submission, when you look at all of this, is that this area of the law has never followed the common law default rules on agency. It hasn't. It has departed and has taken its own course to say, we will tell you when you can have agents and when they have to be authorised in writing. And they certainly were not in the statute of frauds proceeding on the basis that the party covered agents, because special provision had to then to be made for agents in 1925. And there's no reason in my submission to think that the change to some person was intended to bring agents in. Now, I do have to address to some degree the authorities.
You would also say that saying that, well, it's because the agent has to be authorised in writing that the express mention is made, won't suffice as an answer, because section 4 of the statute of frauds simply talks about some other person thereunto by him lawfully authorised.
Yes.
So it doesn't have to be authorised in writing at all.
No, even the statute of frauds made those distinctions, and it did it in section 16 as well.
Yeah.
So it was perfectly capable of doing that. So you will perhaps see why I say that the legislative history really quite strongly supports the inference that agents were not intended for B. I should deal with the authorities. I'll try and be as quick as I can.
Are you about to explain why you say the change was made to refer to some person? I think you touched on it earlier.
Well,
Yeah, you mentioned earlier case law that allowed the trustee.
I've got to come to show
You're going to come on to that.
to show your ladyship the case law about the trustee being able to prove the trust.
And is your submission that the change to some reflected that case law development prior to 19?
Well, I don't think I put it quite strongly as that, because one
Okay.
can't. It's difficult to make such a specific inference. What I would say is that the statute has to be construed in its context and the context of the law it's enacted into. And the state of that was the state of the law in 1925, that in a transfer case, the trustee could declare the trust.
So there were alternatives, you're saying, and the state of the case law was that either the transferor or the trustee transferee could declare.
Either the settlor beneficiary, beneficial owner could declare, or in a transfer case, the trustee could declare. That was the state of the law in 1920, still is. I don't put it as high as saying, look, that's definitely why the wording was changed to some person, but it's a reason. It could be the reason why it was, and also I think it's more that it explains why the legislature couldn't just say the settlor.
Well, exactly. I mean, it's because section 7 is very specific.
Yes.
The party, implication only one.
Yes. Yes.
Perhaps implication only one. We don't have an interpretation act at this stage,
Yes.
I imagine. The party who is by law enabled to declare such trust.
Yes.
It's a marked difference between that
And that really must be focusing on the settlor at that time anyway.
Yeah.
Yes. Yes.
Just a further question, Mr. McQuater, and don't expect an answer. It's not intended to be a bouncer, but this is really one from Mr. Dewan, who's clearly the expert on Maitland and legal history. I mean, is there anything in the sort of legal history books as to the fraud and perjury that led to the passage of the statute of frauds in the first place? I can't now remember whether it was a successor statute or something else earlier. I don't think it was, but there must have been something that was happening socially that led to it being passed. And
There is
the thing that went through my mind is whether it was post, because it would, I mean, it was 30 odd years later, but whether it was something to do with the Civil War or something of that kind.
Yeah, there have been some writings about why perjury was thought to be such a
Yeah, and what I'm just thinking about what it was that was going on socially that made them think that they needed to pass it.
If you want to give me a moment, there is a discussion of this in UDA, and I've got it. It's in Authority Bundle tab 133.
133.
Give me a moment. If I find it in mine, I can probably find this passage.
Oh yeah.
It's from yes, the 133, page 3 in the extract that we have. 2769.
It's actually from page 2.
From page 2, I'm told onwards. I've started marking it on page 3 onwards in mine. But there is a discussion about why perjury and subordination by perjury was such a problem around that time. Confusion caused by the Civil War, etc. Developments in English legal law and practice are referenced in page 3. Rise in fraud and perjury.
Abolition of the Star Chamber.
Abolition of the Star Chambers. We're really getting into the history here.
Yeah, one just wonders about the potential for people pretending to be other people or pretending to act on behalf of other people.
I think I do
Which
remember
might
reading.
explain the agency. Well, it might explain two things. It might explain why it's reference in section 3 to an agent authorised by writing, because the principal would have had to give the agent authority, which was evidence in writing. It might also explain why agents aren't dealt with in section 7, because there's the potential for somebody popping up with evidence which wasn't in truth the evidence of the settler at all.
Yes.
I don't know, it's just a...
If I could give that some further thought, my lord, as to whether there's any more light that can be cast on that. It's fine. There's a lot of writing on the statute of frauds, as you can imagine. I think one of my friends' authorities actually has copies of the original handwritten Act statute in one of their articles. Let me revert to that rather
Yeah, I
than
wasn't expecting an answer straight away.
misleading the court potentially. But so I was going to deal, if with your lordship's permission, with the authorities on this, such as they are. And I'll be as brief as I can, because one of the reasons we're here is there isn't a satisfactory authority directly in point. The legal textbooks, there are some which say in terms that agents are not permitted. Those are particularly McGarry, which I showed you, Wolstenholme, which you were shown by Mr. Grant. That's at AB 5132, page 5. Lewin, of course, AB 5163, page 4. Signature of an agent will not suffice. So they've come out against agency. There are a clutch of other textbooks which refer to signature by the settlor, beneficial owner, without mentioning the possibility of agent signature. Some of those pointedly record the fact that B doesn't refer to agents, but the other subsections do. And then there are, in that category, there's Cheshire and Byrne, there's Emmett, Haley and McMurtry, Hudson, other textbooks. There's a whole raft. And then there are some questioners. So there are some questioners who, and what's interesting about the questioners is, for the most part, they start by acknowledging the conventional assumption that agents are not included, but then go on to say, well, maybe they should be. So it's important to note that with the questioners, they start from acknowledging the assumption. has been assumed for 100 years, X or whatever, or it has always been assumed. Thomason hasn't said it's always been assumed to be this position. Mr. Grant showed you these texts. It's always been assumed to be the position. Then they go on to say, well, maybe it should be included in this phrase. There's only one commentator who actually comes out and says, my view is they are allowed, and that's Charles Harpham in that article that I mentioned a moment ago. And his article also acknowledges the controversy, but he is, with the huge respect, an outlier on this point. This is not a mainstream view.
I mean, it's interesting reading that passage. I mean, greatest respect to him. Passage at page 10, when I read it a moment ago.
Yeah.
I couldn't really see that it was particularly compelling analysis as to why agents were included, merely because it was to do with evidence. And
Yes.
Speaking for myself, I just don't understand that.
Yes. It's still something that has to be done by a person, and it's a very important something.
Yeah.
So, with respect, we disagree, and for all the reasons I've suggested to you, Your Lordship,
You might say, I mean, one might think, if one's dealing, going back to the point about the history,
yeah,
if what it's about is about evidence of something, in circumstances where there'd been a concern about fraud, you'd expect the evidence to have to be not only in writing, but if it was by an agent, it would also have to be an agent whose authority was evidence in writing.
Exactly.
Because otherwise you risk fraud by the agent.
Precisely.
Never mind the beneficiary.
Precisely.
Yes. Agent fraud.
Yeah. Is that a convenient moment?
It is, because I was going to go on to the cases. Yes.
If we take 5 minutes by that clock, so just before 25 past.
Very good.
Right.
Can I get past you? Obstruction.
through that.
I know.
I don't think Falk is,
It's still a formality.
but yeah, I can't work out exactly the insurance or about not having a reference.
No, I don't think it's just that.
It's right, it's all.
I think it's a bit of both.
Best of week forensic phone. It is that one.
Your Lordships, my lady. I was going to turn to the cases. I'm grateful that Mr. Grant has been through a number of these, so I can probably take them on quite quickly. The tyranny we've already mentioned in a slightly different point relating to the wills, but if we could just go back there for a second, Authorities Bundle 122, page 1.
2476.
2476. The Master of Rolls, Sir John Romilly, held or said in this case that the declaration required under Section 7 had to be made by the beneficial owner of the relevant interest. We've looked at that before. It's also evident from the head note in the very first paragraph of the head note. Now, his insistence that signature had to be by the beneficial owner has been interpreted by commentators like McGarry as ruling out agent signatures. And tyranny has also been, as you have seen from the Australian authorities, cited by Mr. Grant yesterday, understood in the Australian cases under their equivalent legislation as having the effect that the writing must be signed by the beneficial owner of the land and not by their agent. And Mr. Grant rightly took you to two cases there, Ryder and Taylor. This was under Section 23C, of the Conveyancing Act 1919 in New South Wales. Ryder and Taylor is at AB 4 tab 108, and this is at page 21. 2244 in the PDF. Yes, it's yeah, we got it on screen. The internal page 51 of the report, where Justice Nicholas in New South Wales held that a letter signed by a solicitor was not sufficient. The statute was not satisfied with the signature of an agent and cited Lewin, and that was applied under the Australian equivalent, as I mentioned. Mr. Grant also rightly cited Di Pietro, which is at Authorities Bundle 1, tab 39. Relevant passage at page 11 for these purposes. 660. This is a decision of 3 judges in New South Wales, where they refer to the equivalent legislation at page 11. You'll see the foot of the page, the 23C1B of the Conveyancing Act 1919, and over the page at page 12, just below letter D, they say agent's not enough. 4th line, it's been regarded as established since tyranny that the writing must be signed by the beneficial owner of the land and not by his or her agent. And they cite Ryder and Taylor and Jacob's Law of Trust. Mr. Micken has acknowledged that his argument was inconsistent with the passages in Jacob's Law of Trust summarising the authorities. In my opinion, those passages correctly state the law. That's Mr. Justice Sackville. Mr. Grant's answer to this says it's all a big misunderstanding of tyranny. And it is an available reading of tyranny, and all the commentators here refer to tyranny, the commentators and the Australian cases, and they obviously regard it as a sensible interpretation which should be followed. an Australian judge isn't bound by a 19th century English case, but they have decided that it's a sensible and rational rule which they ought to follow. That is to say that agents should not be included. And it isn't available reading of Teare. If you're saying it has to be the beneficial owner, it's an available reading to say well, that's not agents. There are other English cases which express views about or about 53(1)(b) or occasions make findings about 53(1)(b). We already saw this in Erman's case, which is at Authority Bundle 4 at 114 tab 6. This is the decision of Mr. Justice Lloyd, 2342, and this was actually a decision under a different statute. It's a decision under the Leasehold Reform, Housing and Urban Development Act, 1993, and Mr. Justice Lloyd, we know from the report, was concerned with the validity or otherwise of a notice under Section 42 of that Act, 1993 Act. I mean, the key provision, if you want to look at it, is on page 6. It's just in paragraph 18 on this page, section 99(5), and the distinction it makes between A and B in relation to whether it has to be by the tenant or on behalf of the tenant. And paragraph 34 on page 8 of our report, Mr. Justice Lloyd interprets that statute as rightly requiring personal signature by the tenant in section 42 cases. But going back to paragraph 26, page 7, he refers to paragraph 53, concerns which of course derives from the statute of frauds, and points out what A and C say, whereas B requires the matter in question to be manifested and proved by some writing signed by some person who's able to declare such trusted by his will, and therefore does not permit signature by an agent. As it happens, maybe in consequence of Hayden-Johnson, or Tennyson's Act was amended. So it's strictly speaking obiter, of course, but from an authoritative source, he's saying it doesn't permit signature by an agent. There's a sequel under that 1993 Act in the Cascades case, which is in Authorities Bundle 1 at tab 31. Which is under the same legislation. The Court of Appeal in this decision, AB 31, page 1, 350, the Court of Appeal held that a Section 13 notice must be signed by all the participating tenants. And Sir Peter Gibson at paragraph 7 on page 5 of our report, making that finding that had to be signed by all the tenants. And what one, I won't go in depth into the case, but one sees that Lords Justices Jacob and Dyson agreed, and the court having little sympathy with the logistical problems that were said to arise in this case. And NIOC, of course, says this case was rightly decided. It's true that section was amended to allow signatures by agents, but it rather makes our point that the unamended section meant that signatures of an agent were not sufficient. The other cases that have been cited, the Tessie, the Princess of Luxembourg case, we've looked at, I won't go back to Mr. Grant took you to AB Authorities Bundle 2, tab 63 at 24. 301 1301, Mr. Justice MacDonald expressing the view at page 24 of that report, paragraph 67, that where property is held on trust, it's only the beneficial owner who's able to declare a trust of land for the purposes of section 53(1)(b). It's true he wasn't specifically addressing the question of agency, but there's no suggestion of agents there. That's at as I say, paragraph 67, page 24 in the report. There are then, as we looked at yesterday, there are two decisions of Judge Halliwell sitting in the High Court. One, Fish and Sky, just for reference, it's at Authorities Manual 2, tab 44. Issue there, as you saw, was whether a property transfer took place subject to the secured right of certain investors. And the transferee company called Sky 2 was in administration and had been permitted to sell free of those rights and had taken counsel's advice about whether the transfer had been subject to those rights. And paragraph 51, which I think you were showing, the investors argued that Sky 2 had recognised the investor rights by authorising the solicitors to serve notices under section 5 of the Landlord and Tenant Act. And that was rejected for a number of reasons. But also, I suggest Judge Halliwell in obvious agreement with the Council's opinion that had been taken that the Section 5 notices would not have been capable of constituting a declaration of trust because they were signed by an agent. And the other Judge Halliwell decision is Morton and Morton. It's AB 38229, where there was a dispute over the property of successive partnerships. And the, yes, he stated in that case that the partnership accounts signed by partnership's accountants and not by the partners themselves would not satisfy the requirements of 53(1)(b) for a written declaration of trust. That's at the passage at page 29 of the report. So far as other statutory provisions are concerned, my lords and my lady, we've considered obviously the question of, other decisions have considered the question of whether reference to an agent, the omission of reference to an agent meant the signature was not permissible. We've looked at St. Ermines and the Cascades case. We've also included a couple of cases that are under section 136 of the Law of Property Act. I think it's probably only necessary to go to one of them, perhaps. That's Technocrats at Authorities Manual 4, tab 119 at page 13. 2441. And this is under, this is Mr. Justice Field, and it's under section 136 of the LPA. So we're in the same statute. This is in part 4, section 36 is in part 4, equitable interest in things in action in the Law of Property Act. And if one looks at paragraph 53 on that page, he decides that no one other than the assignor could sign. The wording is, well, if I can perhaps just invite you to read the paragraph 53, the wording of that provision is writing under the hand of the assignor. And it's of particular interest, I suggest, because in the second half of this paragraph, the judge specifically drew attention to the fact that section 40 and section 53 specified when an instrument could be signed by an agent and regarded this as a similar issue. And finally, you had cited to Banbury and the Bank of Montreal, which is at AB1 tab 27. 229 in the PDF. This is a House of Lords case under Section 6 of the Statute of Frauds Amendment Act 1828. You see the terms of that act on page 4 of this report in the bottom left-hand corner. This was the case, as I think may have been explained by Mr. Grant, that the bank manager had given oral investment advice, and the main finding by the House of Lords was that the Act applied to fraudulent misrepresentation and not to negligence cases. And Lord Wrenbury in the House of Lords found at page 88, in the long report, page 88 of our bundle, 316, that a signature of an agent would not suffice for the purposes of Section 6 of the Statute of Frauds Amendment Act, and the principal to be charged by their own signature had to be attached to the document. Now, NIOC accept in their skeleton that this case is right, save they say that if it was decided now a signature would suffice if it was a corporation after the UBAF decision. We obviously disagree with that. It was a corporation in Banbury, it was a bank. The House of Lords said agent signature would not be sufficient, but yeah, perhaps I do need to touch on Banbury again when we come to the application to corporations. So we're not pretending the authorities are inconclusive, but there is some guidance there, and insofar as there is guidance, we would suggest that they are flowing in our direction. Now, to address my ladyship's point about trustees can provide the proof of evidence in transfer cases, if we could perhaps look at Lewin on Trust to start at AB 5, tab 163 at 5. 3261. 3261. If I could do a couple of commentaries and then go to a couple of cases on this. The means of satisfying the section, top of the page. The section is satisfied if the trust is manifested and proved by any subsequent acknowledgement by the trustee as by an express declaration by him or any memorandum to that effect. And he gives other examples of the trustee giving the evidence. Virgo is to similar effect at AB 5, tab 164, page 3.
So that doesn't, the passage has shown us, does that only dealing with where the trustee is someone different from the settler?
I'm not sure it makes it clear. I'm just seeing which case was cited there, 68. Yeah, they've cited Foster and Hill. I think they must be making the trustee point, otherwise, if you look at the footnote at 163 page 8, footnote 68, which is cited there, as it says, as explained in Foster and Hill, a person having the right to declare himself as a trustee. Now that would be obvious if it was just the beneficial owner, but they're talking about something more than that here, a person having a right to declare himself as a trustee. Now, there is actually, I mean, Gardner and Rowe was a trustee declaration case. There is some authority on this. That was a case of the trustee making the declaration.
The transferee trustee.
The transferee trustee making the declaration, which I'll come to. And I'm just checking to see if Virgo is any clearer on the point that the Lordship just raised. Yes, Virgo's a bit clearer, which is it Authorities Bundle 164 at page 3272. This is from Virgo Principles of Equity and Trust, and you'll see passage I've gone to for a different purpose before, the last 4 lines of the first passage on the page. Although the signature will normally be that of the settlor, it can be that of the trustee. And they cite Gardner and Rowe in footnote 8. These formalities are required as a safeguard. I've read that already on the purpose. And UDAN addresses it at Authorities Bundle 5, page 133, tab 133, page 12. 2778. In channel page 317, yes, the first main the first full paragraph on that page, worded the provision would suggest that only the beneficial owner, not the trustee of the alleged new trust, can make an effective writing. It appears, however, that the writing signed by the trustee is sufficient to satisfy the requirements of the statute of fraud, and cites 2 other commentators in the footnote.
When it says the wording of the provision, is it talking, are they talking about the LPA there?
It's actually talking about the statute of frauds, in fact. It is.
Well, that makes more sense.
Yes, yes.
Yeah.
Slightly oddly, the whole article is premised, even though it's written when it's written, 1984, is actually premised as analysis of the statute of frauds, even though
And in the present tense.
yes, it writes in the present tense, which is interesting as the reader when you come to it first off.
Explains that in footnote 3 on the first
yes,
page.
yes,
Despite the replacement of section 7 by section 53 of the 1925, I shall refer to the original provisions. This is because the modern English provisions do not, I think, make substantial changes relevant to this article.
yes,
So,
yes. It's actually, yeah, so the comments are directly related to the statute, the equivalent statute of frauds provisions. Well, let's go to Gardner and Rowe, because I don't think there's any controversy about in transfer cases trustees being able to make the declaration. You can see it from the judgments in Gardner and Rowe.
which is
It's a Authorities Bundle 2. I'll start with page 50 because it's the tab 50. So AB 2 tab 50. 901. And the I may have to go back to this case, particularly under ground 3, but the it's an 1825 decision of the Vice Chancellor upheld by the Lord Chancellor, decided under the Statute of Frauds. The present purposes, the point is that it was a transfer on trust case, and the evidence of trust for the purposes of Section 7 was provided by the trustee. You actually get that from the head note of the facts. If I can summarize the first paragraph and a half of the head note, a lease was granted to one Wilkinson, who subsequently became bankrupt. And after his bankruptcy, Wilkinson, executed a deed declaring that he was the trustee of the land in favour of one Rowe. A jury trial was directed, as we know, I think we saw previously, by the Vice Chancellor, and that jury trial found that the lease had been transferred to Wilkinson as trustee for Rowe, and the Vice Chancellor found that the declaration by Wilkinson, who is in the trustee position, was sufficient to satisfy the statute of frauds, and that's at page 4 of the judgment at top of the page. Picking up from the second line, I cannot find a principle why it should not prevail against the assignees if executed the day after the bankruptcy, especially when it's considered that a trust is not passed by assignment to the bankruptcy. For these reasons, I have opinion the indenture they're executed after bankruptcy is a good declaration of trust in favour of J. Roe within the statute of frauds. I can understand why your ladyship was quizzing me a bit on this, because there's a statement in Tierney that seems to take a different view, which seems to say a trustee's signature is not enough. And I think there are 2 points on that. One is that you may remember that Tierney is in fact effectively a sub-trust case. It was A, B, C, and B was, as the beneficial owner, was declaring a trust in favour of C. And they were in those circumstances saying, well, it's not A's signature that counts, it's B's signature that counts. So it's not actually quite as it seems when it makes those comments about the trustee. And also, we've got Gardner and Rowe, and after Tierney, there were a number of English and Commonwealth authorities which proceeded on the basis that in transfer on trust cases, the trustee could provide the evidence. I mean, one of them in the bundles is Smith and Matthews. I wasn't intending to go there unless we have to, but the Commonwealth cases, there's New Zealand case, Mountain and Styack, and so on, which seems to make the proposition really quite, these are all quite old cases too, quite uncontroversial now. Perhaps there is another reference that might help. Now, I think I've showed you the Lewin footnote.
Well, in a way, the statute's there for the protection of the transferee trustee, because the transferor hasn't got rid of him. He doesn't care much now. He's not affected, or she's not affected by the later trust. So really, it's all about the transferee trustee being affected by some oral trust.
Yes, in a transfer and trust case, you can see how there's a protection of the trustee element involved in that. Yes. In a self-declaration case, I mean, it's the settlor or beneficial owner who is effectively the trustee, but they're obviously declaring as settlor or beneficial owner. But the relevance of this, as I mentioned previously, is really that if you're looking at what the current state of the law was, it's a reason why potentially the Act it didn't confine itself to saying the settlor. Incidentally, as a matter of analysis, by his will would also work for trustees in transfer cases, because in a transfer case, the trustee being on the authorities, some person who's able to declare the trust, then they ought to be able to provide the evidence in their will. And
It's their property.
well, the trustee of the property, yes. Yeah. So we can't see a problem.
Conversely, excludes it from the will by declaring it, because by declaring themselves a trustee in their will,
well, they're
making it clear that they're not.
Yes, the beneficiaries don't. Beneficiaries of the will don't benefit. Yeah, yes, yes, yes. I mean, I think I wonder if it's worth getting into this, but I mean, it might be worth mentioning that the phrase "some person who is able to declare," the word "declare" isn't necessarily used in an entirely conventional way, because the settlor, once the settlor has made its initial and irrevocable declaration, isn't thereafter, on one view, still able to declare a trust in the strict sense, because they've already declared it, and potentially the beneficial interest might already have passed. And a trustee who's declaring the trust isn't actually the one declaring, because the settlor has already done so. So on one view, it seems to mean declare in the sense of being able to make the trust effective, in which case it's a particular term of art that the legislation has used, and we need to work out what it includes. And it's not just a read across from somebody who in law might be able to declare the trust. It's who we recognize as a matter of law and statutory construction is able to make the trust effective in this context. Which brings me conveniently to the point about whether an agent's able to declare a trust over land anyway.
Before you get to that, can I ask another awkward question? Which is, we looked at textbooks. I think none of the text precedes the 1925 Act, do they? I thought I saw a Lewin edition that's much older.
There was a reference.
13th edition.
13th verse 1928, I think.
Yes.
So one point in your favour might be if prior to the 1925 Act, the textbooks consistently or mostly took the position which is taken in, for example, McGarry and Wolstenholme now.
Yes.
Has anyone sought to look back that far to see what the textbooks say?
I will check. We've looked back pretty far. The dates of some of these writings. We haven't got anything that precedes. There.
I think that's right. Lewin from 1928 is the earliest.
The earliest,
Comment
yeah.
we have.
There's no commentary on the statute of frauds in the previous edition of Lewin.
I think there is. Can we take that question and see what we can provide that might be of assistance on that? And if it's favourable, I can berate my team for not finding it earlier. So on the question of is an agent able to declare a trust over land? As I mentioned, it's asserted by the appellants in this case. The authorities don't establish that proposition in relation to land. And we can't find an authority that establishes that proposition. It's not so far as we're aware been tested. We don't regard it as obvious, since in this area, as I mentioned before, area of the law, it hasn't ever really followed the common law rules on agency. And as I mentioned, the authorities did not even establish that proposition in a convincing way in relation to personal property. Now, one can have a debate about why shouldn't the common law principle default position apply. But dealing first with the authorities that are cited by NIOC, they cited 3 authorities to establish their proposition, but they've added recently a 4th one. The first is the High Commissioner of Pakistan case at AB2 tab 57, page 95. 1116. Yes, we've gone right. Give me a second. We're going right to the relevant page in Mr. Justice Marcus Smith's judgment, and paragraphs 246 to 247. We see this. In this case, the settler would have been Nizam VII. The money was his, acting through his agent Moyne. However, since I found that Moyne had no authority to effect the transfer, whether on trust or otherwise, it follows that no express trust can arise. If contrary to my finding, Nizam did give Moyne authority to make the transfer, then that authority would have been along the lines set out above, would have been a broad authority to safeguard assets. Assuming contrary to my primary finding, Moyne did have authority, it's necessary to consider the question of intention more closely. The judge in that case, it concerned money, and the judge in any event found that the agent had no authority, so no express trust came into being. Reliance is also placed on Pennington and Wade, which is at AB 4 tab 95. (2027) decision of the Court of Appeal. This was a case of, again, of personal property. It was shares, and was decided on the basis that the share owner, Ada, had signed a share transfer form. We see that in the report. I won't read the whole head note, but we can see that in the report, perhaps if we go to the foot of page 3, we see just below letter H, in the last few lines, the reference to Ada having signed a transfer form, paragraph 3 of Lady Justice Arden's judgment as she was. And then Ada had also countersigned a form whereby the recipient of the shares consented to act as a director under the articles. The director had to hold shares in this company. We see that from paragraph 4 at the top of the next page. In paragraph 4, one sees that she'd countersigned the consent. And it was held in this case that it would have been unconscionable for the then deceased donor to recall the gift. And the case was decided on a constructive trust analysis. If we look at page 14 of the report, paragraph 57, second equity has tempered the wind of the principle that it won't assist a volunteer to the shore and land the donee by utilising the constructive trust. This does not constitute a declaration of trust and thus does not fall foul of the principle of Milroy and Lord. That an imperfectly constituted gift is not saved by being treated as a declaration of trust. There's reference to the Privy Council in Chotram. And then she says this particular trust obligation was not a term of the express trust constituting the foundation, but a constructive trust adjunct to it. So too in Rose, the court held that the beneficial interest in the shares passed when the shares transfers are delivered to the transferee, and the consequently transferor was a trustee of the legal estate the shares from that time. So it was in fact decided on a constructive trust basis. I think the reliance the appellants seek to put on it is the suggestion that Ada had created an express trust through her solicitor. There's reliance on McGarry on this, saying the passage in McGarry suggesting that in conveyancing transactions, solicitors are always creating trusts for their clients. That's at AB 6 tab 167. Three two eight. And this particular passage is at page 13. 3340. And it's a passage that goes on over off and on for 3 pages, but it concerns trusts which the law imposes on the vendor and purchaser of land, and in particular the vendor-purchaser constructive trust, which the Supreme Court has recently reminded us in LA Micro is a constructive trust. And it is just not apt to analyse those cases as agents being authorised to create express trust over land. The agent's authority to enter into a contract of sale of land is governed by statute, section 40, now section 2 of the LRMPA, that expressly permits, as we've seen, agents to enter the contract of sale. And as McGarry says, if we look forward to 1405, para 14052 on page 14 of this extract, the top of the page, as between the parties to it, contract creates a relationship of trustee and beneficiary, although it is one which does not of all the incidents normally associated with the trust. The vendor is said to be a trustee for the purchaser. The purchaser is regarded as a beneficial owner, at least for the purposes of disposition. However, the nature of this trust must be carefully understood. It's a trust to give effect to the contract, and as such it is governed by the terms of the contract. Although it is as against third parties, it creates an equitable interest. The property consequences between the parties themselves are limited because the vendor retains a lien over property for the price. So it's a particular kind of trust imposed by the law to assist the performance of the contract. And the solicitor's ability to enter into the contract and therefore create in law or have the law impose a trust is itself governed by statute, was section 40, now section 2. It isn't authoritative a proposition that agents can create express trusts on the authority of their clients. The appellants have also very recently added a Court of Protection case that I think we did look at briefly at AB4 tab 105, page 1. 2160. This is a case where the Court of Protection decided there was a need for an application to the Court of Protection where the Criminal Injuries Compensation Authority had made a compensation award on the basis that it was to be held on trust for an incapacitated person. And if we look forward to page 3 of the report, in the middle paragraph, the findings at paragraph 6, we see that, sorry, I've got, I need to go further ahead to see Mr. Justice Charles' finding. That's Senior Judge Lush. Just sticking, Mr. Justice Charles's decision is elsewhere. It's actually if you forgive me, it's in Authorities Bundle 2, tab 40. Page, this is Mr. Justice Charles' decision where he disagreed with Senior Judge Lush's finding. At tab 40, page 3, 671. Yes, sorry, I'm there now. At paragraphs 5 to 6, the findings at 5 and 6 here, he understandably disagrees that it was necessary for the Court of Protection itself to sign off, and that it was sufficient if the court had appointed a deputy to make the claim, and the deputy would be sufficient, which is what he finds at 5 and 6. Now, it's obviously very context specific in a particular statutory regime, and it's not deciding anybody has a broad discretion to create a trust as an agent. And it's, of course, it is not land. It's also interesting from a point which appears, if we can go back briefly to Senior Judge Lush's decision. Now, Senior Judge Lush was the judge of the Court of Protection for 20 years, and it's interesting what he says back on
Tab 105.
Authorities Bundle 105 and at page 3, 2162 in the PDF, that he says in the last lines of page 3, he says, for similar reasons, but essentially because it's a decision that the donor must make personally, I very much doubt that the creation of a trust is something that the donor of an enduring power of attorney, a lasting power of attorney for property and financial affairs can lawfully do by an attorney. Now, as I said, Senior Judge Lush was the judge of the Court of Protection for 20 years, and he wrote several works in the area, and you might expect him to understand the context surrounding individuals who are subject to the Court of Protection's jurisdiction and who need attorneys. It feeds into a point I'm going to come to on other aspects of the case about how restrictively one reads powers of attorney, because there's law on that. And just to a point raised by Mr. Grant while we're there, as this issue of, well, if you can't declare a trust by an agent, what are people suffering from mental incapacity to do? And the answer is apply to the Court of Protection. or an application may be made to the Court of Protection on their behalf in those cases where it's felt it to be in their interest to declare a trust. So that's the unimpressive array of authorities to say that agents can declare trusts of their principal's property, not even very persuasive on personal property, certainly nothing to do.
Under the Court of Protection type of trust, who's the trustee, the deputy or the Court of Protection itself?
Could I just ask Professor Davis to answer that question for me? He thinks that's too mean, so I should come back on that one. I'd imagine that it's provided for them by the statute, I would expect, so there will be a clear answer to that.
Yeah.
I expect it's in the Mental Capacity Act, as to
Yes,
as
I
to
think it
what the
probably is.
provision is. One can also see in the cases quite a strong resistance on the part of the court to find that on their face, even quite wide powers conferred on an agent would confer authority to make gifts of the principal's property. And obviously there are similarities between declarations of trust and gifts, and there are case laws exploring the distinction. They're similar, of course, because in both cases the principal's economic interest in the asset is being given away. And if you look at a case like Reckitt and Barnett, which is an AB4 at 97, page 1, 1928 case. And I think Mr. Grant may have touched on this. We looked at I think at the headnotes on that case, but as quickly as I can, P in the headnote gave a wide power of attorney in favour of T to endorse or sign checks and execute other documents. And on the bank questioning the drawing of checks, P gives the bank a letter saying that, P gave the bank a letter saying that he wished the power of attorney to cover the drawing of checks without restriction. And T uses the authority then to pay his own debts, to draw checks to pay his own debts. And Mr. Justice Russell, in the minority in the Court of Appeal, who was upheld in the House of Lords, he said in the report, if we go through to page 25, foot of 2086. He said in the last few lines on that page, the primary object of a power of attorney is to enable the attorney to act in the management of his principal's affairs. An attorney cannot, in the absence of a clear power to do so, make presents to himself or to others of his principal's property. Thus, it has been held by the Court of Appeal that a power to mortgage does not enable an attorney to execute a mortgage of the principal's property. Sorry, we need to go over the page, 26. Does not enable an attorney to execute a mortgage of the principal's property to secure an existing debt of the principal. Such mortgage was held to be invalid. And just very quickly, that was approved by in the House of Lords, page in the same report. No, different report, AB 98, AB 498, page 8, which is the House of Lords report, 2102, where this is, I think it's Lord Hailsham, is this Lord Hailsham? Yes, it is. Lord Hailsham says in the middle of the page that Mr. Justice Russell was quite right about that. He appears to be quite accurate in his reasonings and his conclusion, Mr. Justice Russell's judgment. Now, I was going to quickly show you Bowles of the Court of Appeal case. It's in a similar vein. It's at AB4, tab 99, which is Court of Appeal decision 1874, and I'm going to go to page 3 of this report, 2117, where Lord Justice James says this in the marked passage: whatever might be the legal effect of the power of attorney under which the mortgage was executed, it was clear that it could not authorize the donee of the power to execute a deed as a voluntary gift. And there's a similar approach you can see in a case, the Commissioner of Pakistan report cites at length from a Court of Appeal case, which the Court of Appeal case was Day and Day, but we can see it in the Commissioner of Pakistan report at AB 257, page 98. And Mr. Justice Marcus Smith citing from Day and Day, and if we can, yes, take it at page 98, just the passage below letter C. He's citing, this is paragraph 28 of the Court of Appeal in Day and Day, where it says, in fact, apart from the generality of the power of attorney itself, there was no evidence of the intention of Mrs. Day was that the solicitor should carry out the proposed transaction in any way he chose. The mere statement of such possible intent shows its inherent improbability. It would mean that it would have been Mrs. Day's intention, and within the solicitor's actual authority, to permit the solicitor to arrange for the property to be conveyed both legally and beneficially to the defendant alone. I cannot see how such a remarkable conclusion, so obviously against Mrs. Day's interest, could be supported by the mere existence of a general power of attorney, indeed anything short of the clearest evidence that those were her actual intentions. I mean, in another part of this case, when we get to the power of attorney actually in our case, I'll be making reference to these cases again, but at least we've seen them now, but it's thought by the Court of Appeal to be a remarkable conclusion that the solicitor agent would be authorized to give the principal's property away, even having a general power of attorney. Now, as to why common law rules about agency might not apply in this context, it's not something your lordships, lady, necessarily need to decide on this appeal. But one can see why the common law default rule might not apply to declarations of trust or declarations of trust of land. And the two arguments, I mean, two of the arguments would be, one is that it's implied by section 53(1)(b) itself. And the second is that a self-declaration of trust is something that has to be done personally, absent statutory authority. And as to the first point, I mean, I've put before you all the arguments which we say show that the statutory intention was not to include agents in the phrase, some person who's able to declare a trust. And when you take proper account of all of those factors, the difference in wording, the intentionality, etc., etc., when you take account of all of those, and the fact that this area has never really followed the common law default position on agency, it's not a huge jump to saying that the legislature's deliberate omission of agents from section 53(1)(b), that by that deliberate omission, the legislature was also saying agents cannot declare trusts of land because they're not some person able to declare such trust. That's not something we need to, that the court needs to decide on this appeal. I'm just indicating that one can see the logic of where the argument would go. The other argument would be that the identity of the settlor is so important that they have to do this personally, because self-declaration in particular is such an incredibly powerful thing to do, alienating property for no consideration, creating trust and fiduciary relationships, land being a special case in law and a limited resource, and the cautionary and evidential functions of this action are better served if only a settlor can declare the trust. Now, you saw that in the Court of Protection case, the senior judge last very much doubted that you could, even with a lasting power of attorney, you could lawfully, as an agent, declare a trust. Now, it may be there's no authority in point, because with land transactions, the solicitor will often get the client to sign, save where agent is expressly allowed, Section 40, now Section 2 of the LRMPA. But I think the point of going into this a little bit now is to indicate that there are reasons why it may not be appropriate for an agent to be authorised to declare a trust of land, or at least without the clearest express authority. There are questions about, is it in the principal's interest for their property to be given away, for the agent to be imposing trustee duties on the principal, and so on. But even if it's inconclusive and unresolved and there isn't authority on it, I think one can take something from it. One can take, well, perhaps two things one can take from it. One, that the cases show how unusual it is for agents to be able to give away their principal's property. That is quite apparent from the cases. If it's possible, it's unusual, and you would require the clearest express authority. And the other point, which goes possibly more directly to the statutory interpretation point, is the lack of authority or certainty on this does mean that it's not at all obvious that the legislator would have intended in 1925 to bring in agents, indeed orally appointed agents, by the side wind of using the some other person language. My lords, the last subject, just to close on the ground one, is the application of Section 53(1)(b) to companies, which I haven't addressed. There is a sort of bit of an overlap with ground two, so this is.
Do that tomorrow.
We could do that tomorrow, my lord. It really segs very nicely into ground two, actually, yes.
Yeah, well, why don't you do that at 10:30 tomorrow? I don't think we're in any danger on time, are we?
We're not in danger of time, but I've just, as your lordship's been speaking, if I've got 2 minutes, another point just on ground one has occurred to me that I didn't cover. If I could deal with that for 2 minutes and then
Yeah,
before
okay.
we rise.
Okay.
It's just this, it's the issue of construing Section 53 against the background of the common law. And the point is simply this, what Benyon says about this is, and these are my friend's citations, I'll just give the references. Authorities Bundle 5 at 152, page 105, 107 and 109. I won't go there at the moment, but essentially what Benyon says is an act may incorporate or retract aspects of the common law, expressly or by implication, that where there's a provision in a statute requiring a document to be signed by a particular person with nothing in the subject matter or context to indicate that personal signature is necessary, then according to the common law rule, a person may sign by the hand of another. And then finally at page 109, Benyon says, although principles of agency usually apply, this is not an invariable rule, and there are cases where a reference to a person has been held not to include agents. The question of whether agency is available involves applying the usual rules of construction. So we're back to the same question we were debating. It doesn't really take us any further. My lords, that is an appropriate point.
10:30 tomorrow.